through that with our panelists who are furious with this court ruling. Also on our top story tonight is Bengaluru cafés and the Bangalore Hotel Association members are now mulling over charging for a table per hour basis. They claim that people hang around sitting at restaurants for so many hours, denying real paying customers a table, while on one hand you have people sitting for that many hours, barely have one coffee and leave. So is that something that might just even be implemented pan-India? And also our top story tonight is ruckus in the parliament. Rahul Gandhi versus Hardeep Singh Puri, war of words. We're going to take you through those details. The headlines first. Supreme Court seeks report of the AAIB's fact-finding inquiry into the Air India Ahmedabad crash. Apex Court sets 3-week deadline for the report on the crash that killed 260 people, including 241 on board passengers. Assam BJP expels social media co-convener Ron Vikas Gaurav, responsible for posting controversial video of Chief Minister Hemanta Biswa Sharma's point-blank video on the party's social media handle. The centre tells the Supreme Court that it cannot release Ladakh-based climate activist Sonam Wangchuk, detained under the NSA in connection with the violent protests in Leh. Babri replica construction now begins in West Bengal's Murshidabad amid donations and unity slogans. Political temperatures now soaring as the Janata Unnayan Party chief Humayun Kabir's project sparks polarization charges, and this of course sparking tensions ahead of elections in West Bengal. DK Shivkumar hits out at the centre over Vande Mataram, says the Congress gave the country Vande Mataram and respected it. BJP have no option but to follow all that Congress has given to this country, is what DK says. Remarks coming in right amid the centre's decision. Guidelines given for all institutions or places that have a formal function must have the Vande Mataram played out first. That too, the full 6 stanzas of Vande Mataram, that's about 3 minutes 60 seconds, before the national anthem. RCB match clearance hinges on crucial government review of Justice Chuna's panel. The Justice Chuna recommendation and crowd safety readiness. Final decision expected on this after tomorrow's meeting. White House softens claim on India-US trade deal. Pulse's tariff cuts dropped. Digital tax rollout diluted as revised fact sheet reflects sensitive negotiations and India's pushback. All right, tonight, a ruling that's set to ignite a national conversation on how law really defines harassment and what really means when a man touches a woman. Does it really mean outraging modesty or not? Now, we're looking at the court saying that if a man touches a woman just by mere contact does not mean that he is outraging the woman's modesty. Now, the case stems from a 2023 case, a 2023 issue that was of an IIT Guwahati professor that he was booked under section 354 of the IPC. In fact, this case that was in IIT Guwahati, where a woman in 2023, a professor, she accused this professor of holding her hand. And an FIR was charged, and it appears that the court now, many years later, decides that the FIR against him must be quashed. So to elaborate this for you, in 2023, an IIT Guwahati professor was booked under section 354 of the IPC, which is a serious non-bailable offence that deals with assault or criminal force used with the intent to outrage a woman's modesty. Now, the allegation is that he held a complainant's hand and made inappropriate remarks while dropping her off. FIR was registered and a charge sheet followed. Now, the Guwahati High Court has quashed this FIR. The bench led by Justice Sanjeev Kumar Sharma ruled that mere touching or holding hand of a woman does not automatically amount to criminal force under section 354. The court observed that for force to be established under Section 349 IPC, there must be a change in motion of the person as a whole, not merely just contact with a part of a body. And crucially, there must be clear intent to outrage modesty. The FIR, the charge sheet, the proceedings, now all have been quashed after the Guwahati High Court's verdict. In fact, the law requires now the use of criminal force or assault to describe outraging a woman's modesty. A 2023 judgment as well from the Kerala High Court had also similarly indicated that merely holding a woman's hand, depending on the context, may not always constitute the criminal force necessary to attract Section 354. Now, does this interpretation really safeguard due process and prevent over-criminalization? Or does it risk raising the bar so high that certain forms of unwanted physical contact fully fall outside the protection of the law? When courts stress criminal force and specific intent, what message does it really send out to women who are navigating all kinds of harassment in workplaces, in campuses, and wherever? Where should the legal line really be drawn? Let me quickly bring in Dr. Vageshwari Deshwal, who is a professor of law, University of Delhi, Barkat Rehan, activist and president, Purush Ayog, Rekha Agarwal, advocate and women's rights activist. Thanks very much, all of you. A clear-cut question. Just by mere physical touch does not mean it outrages the woman's modesty. This is the Guwahati High Court giving out a verdict, and this could set precedent. Dr. Vageshwari, would you welcome a verdict like this?
The thing is, the verdict says mere touch does not amount to outraging their modesty, because that is what the law says. The law says the touch has to be either with an intent or with the knowledge that it is something which is likely to outrage the modesty of a woman. What is problematic is the way it is being sensationalized by the media. We've just picked up a part of the judgment without contextualizing it in a whole. And that is the message that is going out. See, the law is there to protect women, and this provision that we are talking about, Section 354, which is now Section 75 of the BNS, now that is not the only provision that protects women against these kinds of sexual assaults. We have Section 75 of the BNS, which was earlier 354A. Then there is 509 of the IPC, which is now Section 79. So there are multiple provisions, and what has happened in this case is that this girl, she first went in for a departmental inquiry, because she also knows that in a criminal court, it is very difficult to establish. In criminal cases, we are looking at evidences, we are looking at witnesses. In sexual assault cases, there are none. These are private offenses, and the burden of proof is on the complainant here, and she has to prove the allegations beyond reasonable doubt. It is practically impossible for the woman to establish that whatever happened, it was something which was extremely offensive to her when it happened in the back seat or rear seat of the car of the professor. So of course she was bound to lose this case because of the high level of burden of proof that we've placed on the woman. But what exactly happened in the departmental inquiry, that is something which needs to be looked into. And moreover, these kind of verdicts, these are extremely demotivating for the women's movement when we just pick and choose such particular statements.
I mean, I didn't quite get it. Are you saying that this is wrong precedent, or are you saying that the media is selectively choosing a negative side out of this?
What I'm saying is
exactly
both.
My question.
See, both. My point is, one is this kind of a precedent, why it is demotivating is because girls would be now scared. This kind of a statement.
So stick with that. So stick with that.
Touch is extremely significant in our culture.
That's it. So
if somebody
that's the moot
touches
point,
me against my wish, that is obviously abuse or harassment. But the law saying mere touch is not harassment. How do you establish the sexual intent? Even if there was no intent, but of course, the man knew that if you are touching her in an inappropriate manner, something which the girl doesn't like.
So what I understand is you don't welcome this verdict.
Of course, I don't.
All right. Miss Rekha Agarwal, you want to come in on this? I find it very surprising when it says mere touch, but this is not mere touch. The girl clearly said he held my hand and said something. Now, what he said, I don't know, but he held her hand and said something. Now, he's a professor and she feels that she was intimidated by this professor, and he held her hand without her. Of course, it was violating her space, and holding hands is not mere touch. Holding hands is clear intention.
I just heard what Professor Vageshwari said, and I do appreciate the reasoning that she has given behind it, and I also appreciate her angst at the way the media is portraying it by using the words mere touch. But speaking from the legal point of view, the law clearly says, now whether we agree with the law or not, that is a different matter. We may or we may not agree with the definition of Section 354 IPC. And I think that Professor Vageshwari may agree with that. The law says that mere touching, unless there is a criminal intention behind it, unless there is a sexual intention to outrage the modesty, unless there's a mens rea, because one cannot lose sight of the fact that when we file a FIR or a complaint against any man, look at the far-reaching consequences that it has against him. He can be punished, he can be sent behind bars, there'll be a fine attached to it. He loses his face, in society. It's a big stigma. So that is why, keeping that in mind, that look at the consequences of a complaint like this, the Section 354 is very clearly worded that such action should be there, such kind of a reason should be there behind the accused person when he's supposing we have to prove him guilty of the offense of Section 354. Now over here, the complainant in this case has probably based, I have not read the FIR, but probably based her complaint on the basis of an emotion and a perception that maybe the professor had an intention to outrage her modesty, because her complaint rests on the fact that he touched her hand. Now, obviously, nobody is going to like it. If I was in her place, even I would not have liked anybody touching my hand, because unless I am giving my consent to it. So once it is not consensual, therefore, definitely it outrages my modesty. If I was a complainant, but can I book the person under Section 354, which is going to have, which is a criminal offense? And that is why probably I think I would state over here that this judgment, though the way the media is kind of portraying it by using the words continuously, mere touching doesn't amount to harassment. It kind of trivializes the complaint made by the woman, that yes, she did suffer. So she did suffer some kind of a harassment. But can the man be made to face criminal charges? Yes, he can be made to face criminal charges if the woman is able to prove that this was the intention behind it.
Okay. So ma'am,
yes,
49 and
so
354.
I would say,
if you could give me some clarity on what does Section 349 and what does Section 354 really entail? What under IPC, what punishment do you attract? What is the allegation under 354?
The allegation is that there has to be harassment with an intention to violate her modesty. Now,
from what I understand is then if the court is saying that it does not come under Section 354, yes, then we're basically coming down to saying that touching a woman's hand is not harassment against her will.
Just a minute. Now, this is a very fine line. This is a total grey area. It is harassment, but does that harassment come under the ambit of criminal law as to send the man behind bars and to put a stigma and to in entire career and his reputation? No, unless there's a criminal intention behind it. And that is
what is criminal intention? How do you describe criminal intention? If you're touching a girl's hand out of will, if she's not giving you signals, a man touches you, is that not criminal?
Nabila, I just use the word, it's a total grey area. There's a very thin line. Whether he had a criminal intention or not, whether there was any mens rea or not. And that is why the POSH Act has been enacted, the Protection of Women from Sexual Harassment at the Workplace. It is because of this grey area in mind that the lawmakers have enacted this law called the POSH Act, which I'm certain that must be there even in your, in your studio, that any woman who faces such kind of a harassment, she can go and make a complaint to the internal committee, which she did. Now, in this case, the complaint was also not proved to the hilt, and that is why the internal committee dismissed her complaint as being frivolous. Now, after the complaint had been dismissed, the lady
know how well posh committees get, how much posh committees try to brush cases under the carpet if it is especially to do with employees. They try to, most of, and I've heard many cases, living examples that I don't want to quote obviously, on how the perpetrators usually get away because the company does not want a bad name, and they often end up calling the woman's complaint as baseless and false.
There is the power matrix that operates behind such complaints.
Yeah, Vageshwari?
Yeah, because there is the power matrix. The one who's the perpetrator is definitely in a more powerful position so as to take chances with someone he believes is subordinate to him or with whom maybe he can take his chances. So that is the reason why those people who are in a powerful position, they are in a position to suppress the complaints and suppress the voices of the women.
Okay. Let me also bring in our men's rights activist Barkat Rehan for a little more on that. Barka, I'd really like to, I'm keen on knowing what you have to say. Touching a woman's hand, in your view, is not harassment? It's not criminal?
Firstly, let's go with the courts. Mere touching does not meet the legal threshold for outraging the modesty of the woman under section 354 of the Penal Code. So here, many times I have said that laws made to protect women are being used as weapons to settle scores. Maybe this case is also the same, and this must end now. When we are talking that sexual harassment cases are not seen properly, how many are false do you even know? Have you ever heard about false sexual harassment cases and where men are dying also? Feelings aren't crimes. You can't send a man to jail just because a woman felt weird law. It's absolutely weird. You can see in the FIR, it took 2.5 months to file an FIR, the revenge FIR, I will say. She waited for 2.5 months to even file a complaint. She only filed the case after she lost.
I'm not sure.
1 minute, ma'am.
It could be possible that she did not get any relief from the POSH committee internally, which is why she
waited for the departmental inquiry to wind up. She was exhausting the initial disciplinary process before moving on to the criminal case. See, women have their choice. If they want, she can file a criminal case, a civil case, or both. There is no bar.
Not an assault. Let me make clear. Touch is not assault. The whole day we keep on touching each another, and if we consider touch as assault, everybody should be arrested.
This sounds very wrong. Whole day we keep touching each other. I mean, if we are friendly with the person and you have some level of comfort, yeah, well, sure.
But who knows? She wasn't friendly then.
No, see, then again you're vilifying the woman. But then again, see, this is exactly what the woman would have felt, that the fact that she probably shared a ride with that professor, now the woman is going to be blamed. Why did you go in the car with him?
No.
See, we as a society, we are so quick to judge our women.
Yeah, we are very quick to judge
women in the car in the first place.
For the baseless claims, the professor's career was ruined. Mind you.
Baseless claims, okay. So you have already declared him innocent.
What about his reputation? Are we thinking about that?
Okay.
See, even I am not saying that maybe he is at fault or maybe he should be sent behind the bars. I don't say here that he is a criminal. But what I am saying is that the way it has been presented, that
court has already said abuse of law.
That is problematic. Mere touch can also be sexual harassment.
It is abuse of law. Have you read? The court has already said it is abuse of law.
And the judges on the panel are men. The judges on the panel are men. I mean, I wouldn't be surprised if they're saying something like that.
There are so many times when women have said the same thing. It's not men.
Ma'am, these
I know
specific
so many
laws
women-
were enacted to enable women to approach the courts. But these kind of statements, they can be so demotivating. I would now think twice, rather thrice, before approaching even for a genuine cause. Because what if the court says that you are abusing the process? No, I'm just standing up for what I believe is right.
Rekha
But the court
Agarwal,
found nothing in the
it's
FIR
almost,
suggesting.
Ms. Rekha Agarwal, it's almost as if when men say, we are so outraged when men say you're attracting eyeballs and you're attracting rape, you're attracting other crimes because of the kind of clothes you wear. It's almost like this to me. Because that lady went in a car with the professor, she wanted to be dropped off, he probably told her that he'll drop her off. That didn't mean that she was open to having anything with him. He touched her hand inappropriately and she felt outraged. She decided to take this up with the POSH committee. POSH committee has not responded. There was no reaction. There was basically, she did not get relief. All the more probably may have been vilified as to why she went on a car ride with him. And then when she decided to knock the doors of the court, here's what the court says today. Worse is that this could set precedent across the country. Any other case probably on these lines will follow this.
Oh, Nabila, on the other hand, I'm sorry, I don't think that we can generalize that, that she didn't get any relief from the POSH committee.
Exactly.
No,
Exactly, Rekha ji, I was going to say the same. How can we generalize it?
Not find merit in the complaint. So I would rather say
no merit in the complaint.
The use of the words by the honorable judge, I have a little objection to the use of the word mere touch, because that mere touch can sometimes be criminal and that mere touch sometimes may not be criminal. That will depend upon the fact of each case. So therefore, in this particular case, I welcome this judgment. I would rather say that it is not generalizing, it is not portraying women as victims all the time. At the same time, men have to be protected. It is a gender, laws are gender neutral. Section 354.
Exactly my word.
Is not women-centric only. So laws have to be seen not from the eyes of the perception that this is what I felt. It has to be proved to the hilt. Now, as I said in the beginning, maybe Section 354 IPC is not properly worded. We may have differences of opinion about that. But yes, I do not think that this judgment is sending the wrong signal. On the contrary, it is only clarifying that if a woman makes a complaint about harassment from a man, it should be crystal clear. It should have all the ingredients to be able to prove to the hilt in the trial. Obviously, a trial has to take place. Now, will this woman, this complainant, in any case for that matter, will she be able to prove her allegations to the hilt that this is the intention that the man had? Maybe he touched her hand, maybe he proposed. I'm not standing up for the IIT professor in any manner. But at the same time, I'm not standing up for the woman either. A complaint has to be seen from the eyes. As we said, there's a difference between a civil offense and a criminal offense. In the same manner, a complaint made of touching has to, and that is why we have got various judgments right from Bhajanlal onwards. And there's a very major judgment of the Honorable Supreme Court in the case of Major Singh, which has clarified. Now, in this particular case, the FIR has been quashed because they did not meet the necessary requirements which are there for an FIR to stand a trial. That is why the Honorable High Court, the Guwahati High Court, stepped into it and said, no, the trial is going to fail in any case because the ingredients which are necessary to prove that there is a substantial FIR are missing in this complaint. That is why. So nobody is trivializing harassment. Women who face harassment have a right to complain, but yes, they can go to the POSH committee. They can file nobody is stopping a woman from even making an FIR. If a man is touching you with an intent and you feel that his intention is dishonorable, that is a premeditated, exercise action by him, that he is going beyond the limit, that it is stepping into.
So what is the limit? This is precisely what comes down to what is the limit.
At the same time, to each his own. But at the same time,
to each his own. I mean, if there are no standards set, how can you say each his own? Then the next time.
Just a minute. A person cannot be oversensitive at the same time. If you're making a criminal allegation.
Now you're saying oversensitive. Now, see, look, for a person like me, if a guy touched my hand, I would have said, excuse me, I don't appreciate that. I'm not as sensitive enough to go and file a complaint. But there are women who don't like it at all. They have strict boundaries.
Nabila, will you register an FIR if somebody touches your
I'm
hand?
a different person. I'm a different person with a different background, different exposure.
Exactly. You don't know the intentions behind the complaint, why she filed, what was exactly. So not everybody is going to file a complaint, na?
No, so then again, you're basically doubting the woman. Why will a woman risk her own career? No, what do you mean by, when you say we don't know what her intention was, are you really trying to say that a woman like that will risk her own career? What about her own career? She's also embarrassed. Her career is lost. She's probably faced that many years of vilification within the university campus. Her family must have been ignoring her and angry with her for taking this to court. What about the woman's reputation? If you're so worried about the man's reputation, what happens to the woman?
That breaks modesty isn't a glass ornament that breaks every time a man breathes. If there is no criminal intent towards it, there is no crime.
Every time a man breathes. That's why we have the number of rape cases in our country today. Just because they want to breathe and want to be free. They want to be free and breathe. They go around molesting and touching women. Look at the cases that we have in the country. Look at the rape, the cases, molestation and rape. Look at the numbers that we have in our country.
How many are false? Have you ever thought about that?
And compared to the truth? How many are false in compared to the truth? No, what is the number of true cases versus the number of false cases?
In this case, even if you want gender protection, you cannot do gender extortion. In many cases, when these complaints are filed, out-of-court settlements are done where lakhs and crores of money is taken. So what about those cases?
Those are cases that happen. Well, I agree. Those cases are to be dealt with. There should be safeguards against over-criminalization. But what about now? That's precisely my question: is who sets the limit? What is the limit? What is the limit?
And after that, only this verdict has been given. After seeing all the evidences, after hearing all the evidences, the courts have to safeguard the interest of men and women both. We can't be one-sided the whole day. And I'm glad that TV9 has been discussing these cases very often.
All right. Dr. Vageshwari, I'll take your word on this. You have both the ladies saying this is over-criminalization and they're glad that the man found his way out. Just mere holding hand is not a violation of your modesty.
What I just want to say is that just because the rate of conviction in sexual assault cases is low doesn't mean that all those cases are false. There is a high rate of attrition, and not always because it is money that is exchanging hands. Again, because of the power matrix. Again, because of the stigma. There are so many cases that fall out of the criminal justice process, and the message goes that, see, this is a case which has resulted in conviction, so the case was fake from the very beginning. Now, this is a very wrong message which we need to understand and appreciate. Nobody wants to over-criminalize men. We have to coexist in this society, men and women both. But we have to understand the society that we live in, the background that we are coming from this patriarchal society. Why have we enacted these laws in the first place? And then if we ask questions like that, will you go and complain if somebody touches your hand? Oh my God, we've just trivialized this issue to the extent that any girl, no matter how her hand was touched, should be scared of going to the courts because we've just picked up a statement that mere touching of a woman's hand does not amount to sexual assault. Then why do we have Posh in the first place?
And look at the entitlement, right? Like he holds her hand. If this is true, as per a complaint, he's held her hand. It's against her wishes. There you can have a conversation, a verbal conversation. If you really want to propose someone or you want to say what you want to say, you can have.
I've gone through the facts in detail. He was continuously touching his hand.
I'd like to hear Vageshwari on this. I'd like to hear Vageshwari on this.
He was continuously. He was again and again touching the girl.
Hang on, Barka, please. I'd like to hear Vageshwari on this. Yeah. Okay, give me the actual detail. Can you repeat that? What's the detail of the case?
See, they were both sitting in the rear seat. He was reading the girl's palm again and again. He was touching her palm. The girl said that she didn't like it, but still he continued. When they reached the temple, he said, let us hold hands and let us pray together. Now, this is something which the girl found offensive. She tried approaching the departmental inquiry, wherein it could not be established again.
So she said no to him, but he repeatedly tried to touch her despite her saying no.
Yes. And it was literally her word against his word.
Correct.
So we all know that it is very difficult to establish the charges in such cases.
So that's
she was constrained to file an FIR.
Miss Barka, so you basically have to wait for him to assault you or rape you until you file an FIR. That's what you're saying.
But again, modesty is not that fragile.
If
Modesty is
I'm
not
sorry,
that
if a
fragile.
person, I've said no to a man and if he repeatedly touches me, I will file a complaint. And I didn't know this. I didn't know she had repeatedly said no. I will.
And
If it
ma'am,
was me, I would have.
How fragile my modesty is something that I will decide. It is extremely subjective. No
about
one
that?
has any business to
Maybe
tell me
it was
that my
irrevocable.
modesty is fragile or not.
All right. A final word, Miss Rekha.
Well, there's still the Supreme Court. So let us see what happens, because now when I heard the details of the case as mentioned by Dr. Vageshwari, there is a second view about that, because it seems that the touching was not just one isolated act of holding her hand or touching her hand. This is the impression that I got. But if it was continuous, if she was opposing it, she was not giving her consent to it, she was not liking it, she made it crystal clear. Then he went one step ahead and he said, let us hold hands and go to the temple and pray. So certainly the intention was there. There is a criminal mens rea attracted now, which is necessary to prove an FIR. So maybe let us see what the Supreme Court has to say about this. Maybe the order is set aside. This is just the High Court of Guwahati.
Supreme Court? Sorry, can you hear me, ma'am? Has this gone to the Supreme Court?
Not yet,
No.
not yet. The decision has come it has come on 5th of February. We just have to wait.
Yes, it hasn't gone to Supreme Court.
I mean, that will
Not
be
yet.
interesting if it does. All right. But thank you. Appreciate it, ladies.
I have to add one point.
Yeah.
If mere touching is outraging modesty, then every handshake is a potential FIR. Mind my words.
No.
Mind my words.
No, absolutely not. Absolutely not. You know when the person is well-meaning. A woman has an intuition stronger than anyone. You know when it is well-meaning. You know when it is pushy. You know when it is abusive. You know it.
It was
Miss Barka, good touch, bad touch, even a 3-year-old knows today. All right, so I'll rest my case on that. Thank you very much. Thank you. Thank
How
you.
many times did they shake hands?
All right, on that note, we're slipping into a short break. On the other side, we're going to take you through Bengaluru cafes now, deciding to put a price on every table that goes beyond 1 hour. Basically, if you sit longer than an hour and have just ordered coffee, then you'll have to pay twice the amount. More on that on the other side.
भारत की सबसे बड़ी गोल्ड लोन एनबीएफसी मुथूट फाइनेंस से गोल्ड लोन लीजिए और फिर देखिए सोना क्या नहीं कर सकता। कॉल कीजिए 1-800-313-1212।
पढ़ता है, खेलता है, झूलता उछलता है, दौड़ता कभी कभी दौड़ कराता है, आगे आगे बढ़ता है इंडिया, अमूल दूध पीता है इंडिया।
यारा ओ यारा शुक्राना तुम्हारा, सपने हो पूरे हमें ये यकीन है, हम आपके वास्ते हर कहीं है। ओ यार दिल कहे सब तू है रे, बस चाहिए हमें तू खुश रहे, फिक्रे हो उड़न छू। ओ यारा जब मेरे संग
25 साल से आपने आईसीआईसीआई लोम्बार्ड पे भरोसा रखा और आपके सपनों को सुरक्षित रखने का मौका दिया। शुक्रिया इंडिया।
मेरे संग तू
आईसीआईसीआई लोम्बार्ड, निभाए वादे।
Welcome back. Well, sit longer, you may have to pay more. That's precisely what Bengaluru Hotels Association is mulling over. There's a debate brewing in the cafe capital of India, Bengaluru, and it could really change the way Bengalurians work, meet and unwind. And if successful, it may just spill over to other cities across India. Now, when you walk into a cafe for a quick coffee, you may have seen people really sitting around, staying in the cafe for hours, finishing a meeting, catching up with friends, working from a cozy corner on your laptop. Well, that's the cafe culture that the city is known for, and it's been thriving and only growing. Well, but that habit may just come with a price tag. Hotel and cafe owners across Bengaluru city, under the banner of the Bengaluru Hotel Owners Association, are discussing the introduction of table charges, effectively an hourly fee or penalty for customers who occupy seats for long durations after placing minimal orders, maybe just one coffee. The argument from the industry is reduced table turnover, revenue lost during peak hours if they have limited seating capacity, especially in busy commercial hubs. In fact, one cafe in Bengaluru has already reportedly implemented a 1,000 rupee charge per hour for long staying and low spending customers. They also have signages that says meetings are not allowed here. Several establishments have begun informally requesting patrons to vacate seats during rush hours, but now the proposal aims to formalize this practice, possibly even seeking government approval on this. So where did this idea really come from? Well, this model here is similar to parking charges. You stay longer than reasonable without proportional spending, you pay extra. Will table charges really protect small businesses if they're implemented? Will it improve fairness? Ultimately, rent, electricity, Wi-Fi, staff salaries, air conditioning cost, all of that keep running every hour, regardless of how little a customer spends. A family ordering a full meal shouldn't really be denied and be kept waiting outside just to cater to a person or a couple of people nursing a cappuccino for 3 hours. So where's the fairness here? At the same time, we're looking at penalizing customers. Well, this cafe culture in Bengaluru, that people there taking meetings with your laptops, chatting for hours. How much can you really eat, when you have a meeting? You can have a coffee, a couple of snacks. Well, but this culture is really what made Bengaluru at the end of it. Cafe culture in Bengaluru is really thriving, and that's being emulated in other cities as well. People there lingering around over conversations and work. This is what has built Bengaluru's vibrant cafe economy. Now, what's the solution then? Higher bills? Should you buy more? Smarter models like minimum spends, reservations, better seating management? Should cafes really charge for time or focus on winning loyalty instead? In a city of startups and remote work, is this smart business reform, or will this mean an end to cafe culture as we know it? Let me quickly bring in Professor Bijan Mishra, consumer policy expert, PC Rao, President, Bengaluru Hotels Owners Association, and also Binod Jacob, civic activist of Bengaluru. Thanks very much to all of you. PC Rao, I'll start with you. What's the ask? Okay, we seem to have a network issue there. Professor Bijan Mishra, what's your take on that? Charge per table per hour if you're sitting around for ordering not much.
Nabila, you have already packaged it very well in your opening remarks. You have covered all the dimensions. You see, the most important aspect a consumer wants is there should be a standard. I must know before I buy any product or service, what is it that I would be liable to pay, under what quality conditions or what standards I should expect out of that payment. That's the first thing. The second thing is I should have choice. You see, you can't compel me to pay for something which I don't want. So you will have to make sure that, you make it very transparent. You make it very accountable in terms of information. You have to make sure that whatever you want to bring in, it has to be fair. There cannot be any kind of an unfair trade practice to be adopted where you compel somebody to buy something which he doesn't want to buy. So all these aspects, you need to make it very clear right from the beginning and set a standard and tell the customer that, look, I don't mind you coming into my shop and I don't mind giving you the service, but this is the price you have to pay for. And that has to be made very clear before it comes in. And then I heard you saying that they're also trying to get vetted by the government and they want to ensure that it doesn't look an illegal kind of a activity. So I think they're moving
What's the
in the right
solution?
direction.
You know,
in the
how
sense-
do restaurants recover their cost? I did mention on ACs and, you know, staff salaries, your functioning, an entire restaurant or a cafe can't be, you know, often having
No, no.
customers just sitting around ordering a coffee, because then business gets tough.
When you fix the MRP, Nabila, when you fix the cost, you take all the input cost into consideration, and then you come into a markup in terms of this is going to be my MRP. So when you are deciding that, you can't just offhand tell the customer that from tomorrow I'm going to charge you this, or right now I'm going to charge you this because you've just bought a cup of coffee and you sat here for 2 hours. No, that's not fair. That's not a fair practice. You have to give them enough opportunity to make a choice. Whether I want to come to you or not, that's my choice as a consumer. Whether I want to pay you for that extra charge or not, that's my choice. But you can't charge me for something which I was not knowing about.
Okay.
Or I had no information.
But what if are you encouraging of a restaurant saying no meetings here, a board there that says no meetings here? Are you encouraging of the restaurant clearly mentioning that during peak hours the table will be available only for this, maybe an hour? Are you clear? Are you okay with restaurants being very clear to their customers, or is this a way to drive away people? You know, because it's not a warm welcome to me when I'm walking in.
No. It's not a question of driving away. You see, it's a question of your right to choice, your right to information, your right to standard. So as a consumer, I have these rights, and I should be able to represent also. Like if supposing somebody tries to push something on me, which is not comfortable for me.
So that's what I'm asking you. Are you okay if the restaurant is making it clear through signages?
Yes, of course. In a language which the customer will understand. Not you can't put a signage which the customer may not be able to read and understand.
Yeah.
So you have to make it very clear that the customer knows that language and is able to understand before he enters into that premise. And
you know, but actually,
well explained.
I should say that I mean I'm from Bengaluru myself, and I love the cafes there. It's beautiful, but I know where I can sit and where I can't. Okay, so if I go to a Quashes, for example, it's not really a cafe, but it's a busy restaurant / cafe. You go for coffee. Quashes has coffee. Quashes has liver on toast. It has full meals. It has all kinds, right? But I know not to sit there too long because there are people waiting and it's a crowd, and waiters are so well trained. If you're done, they'll come and slap the bill on the table immediately. They will not wait, right? So when the bill is in front of you, you're forced to pay and leave.
I'll have to stop you here. You should go and visit sometime the coffee houses in College Street of Calcutta. You know, the people assemble there just to have a cup of coffee, and you won't believe it, 4 people sharing 1 cup of coffee. You know, my contention is that the restaurant is doing good business.
Yeah.
They are having so much of turnover. You know, the volume is there. The restaurant is not losing business.
Okay.
They want such people to come.
Okay, let's see. PC Rao is the president of the Bengaluru Hotels Owners Association. Sir, welcome. Long time since I saw you. Thanks for joining us. What's really the ask from the association? What are you worried about?
Our main motto is not to punish or not to put any penalty to our customers. Customers are very important for us to hotel business. And in fact, Bangalore has got very beautiful name, having good number of customers, varieties of food at the affordable rate. But the issue now is some of the hotels and some of the customers are misusing our place for wrongly things, discussion of their real estate work or antisocial elements, sitting for a longer time, more than 1 hour. For a cup of coffee, 15 minutes, 30 minutes is really enough. We were not questioning them even for 60 minutes. If they still sit, it will going to disturb the family customers. It is disturbing to the customer only, particularly to the family customer. If they shout, if they quarrel, all those things many places it has happened. This is especially in the remote places like Nelamangala, Hoskote, KR-Puram, in such areas where there are a lot of real estate businesses going on, they're using the hotel table for a longer time. There, we will request them to make a space for the new customer first. But still, if they don't agree, we will show them the board. We will put a board. This hotel is to eat the food. You can enjoy the food. This table is for the customers to have the food only. We have to collect money. It is not a penalty or anything. We are just putting a board, 500 or 1,000 rupees, as if the customer wants to sit for a more time. See, for such sitting for a more time, there are a lot of workplaces are there. There are a lot of
spaces,
other
there
clubs
are libraries. I mean, I don't know, libraries you can't really talk, but there are co-working spaces. Bangalore thrives. Bangalore has a great park culture. There's lots of green spaces that you go and can sit around.
There all it is allowed, but in a place like a hotel which is having 10 tables and 40 chairs, if two or three young people comes and sit, where the other customer will come and have it.
Okay.
And also will be filled by these people continuously.
No, so sir, instead of ultimately, I would, if I'm talking about my personal experience, if I would go into a place where I'm welcomed, where I'm feeling warm. If there is even a little bit of animosity or hostility from the side of the waiters or the restaurant admin, I would walk out and I would never go back to that place because I want to feel welcome. I would probably one day order lots, next day order very little. Day after that, I would have people, friends that I want to treat there. I mean, it all depends on the warmth I get in that place, right? If I'm not feeling comfortable and not welcome, then I would not come back. So will you be risking customers, by doing something like this, by imposing a table charge per hour?
No, we are not penalizing and putting any penalty on them.
But ultimately, what you do might set precedent across the country. Maybe all across India, there could be a rule that will come up that tables per hour could be charged. So, think wisely.
I'll just give an example. Since 3 months, VBMP has started a penalty for if you put a garbage on the road.
Yeah.
And they have collected 30 lakhs. Today, they're putting on the road garbage has come down by 75%.
But you can't compare customers to garbage, sir.
The news has come up from last 3 days.
You want to discourage people from littering.
No,
this is not the same. You can't equate this.
No. I'm just from the last 3 days after this news comes, there is around 50% reduce in the customers staying for a long time. They come and have the coffee now. It's already the way.
So was this a marketing gimmick? You just wanted this to go out in the news? You wanted to go out in the news so that people listen to it and they're like, okay, fine, let's show some respect.
It is a little bit educating the such type of customers.
Okay.
You see, there is a lot of.
But I want to know, Vinod, Jacob, do we know if this is is there anywhere in the world that follows a rule like this? Are we asking for too much, or is this too harsh on the hotel association?
Yeah. Thank you, Nabila, for having me.
Yes.
And greetings to my co-panelists and your viewers. I think there is something called the cover charge and the cork charges and all that in abroad, where it is also discounted on your table when you actually go there and have a cup of coffee or a drink or whatever you want in the restaurants. But being in the hospitality as well as the leisure industry, comfort is one thing that every client seeks in a restaurant. And especially for an IT capital in the Silicon Valley of India, Bengaluru, today the coffee shops are used as an extension of hybrid working office space. So I don't think so. This is a great idea. I'm totally against this, and this should not be made a benchmark at all, because this is going to really affect their business itself. Because today you have, in case you want the best of coffees, it is all the aggregators are there. A Swiggy, a Zomato, a Blinkit, and an Instamart, and at whisk of your fingers, it is available at your home. So why, or for that matter, your office space. So who will visit the hotels? Mr. Rao, who will visit the hotels if these sort of things, cover charges are bought and for people staying? Because I feel that hotel industry is a service-oriented industry and has to be, in that way to this thing. Otherwise, it can be just like any fast food.
I can think the best thing, Mr. Bijan, is training your staff. Do you think that's the best way forward? Training hotel staff should be trained enough to know how to deal with customers in a very polite way, place the bill. The moment you're done with your food, place the bill without any hesitation, ask for the bill to be paid and then say, ma'am, customers waiting, or sir, customers waiting, if we could have this table. That's a very polite request.
Absolutely. Nabila, you're absolutely right. You see, now, even when we go to any restaurant, as you know, the restaurant survival is on the turnover. Now, they've trained their, service providers in such a manner that they are so polite and so courteous, and in a very courteous manner, they would tell you, if they see you that you're just sitting around, you're not ordering anymore, you've finished your meal, they'll very comfortably come and tell you also that, sir, we've got people waiting outside, if you don't mind, if you're finished, and we oblige them. And it's very natural, because sometimes you get so engrossed with your gossip sessions in the restaurant that you don't realize. And then when the service provider comes and helps you to understand, then you acknowledge that, you appreciate that, and you go over. So training is very important. Human resource training is very important in any service industry. In our country, unfortunately, sometimes we don't find it there in that manner which we desire as a consumer. And the owners, they try to bring in a lot of, not as a priority, to give proper training to their people who are working there, give them a class of etiquettes and things like that, how to communicate well. They don't get trained. But some people are born, well communicator, and they definitely also get encouraged, because they know that they will get the gratis, they'll get a tip which would be high, but now that also has got stopped. You see, it's all included in the bill, the service charge. If you want to give,
no, you know what? All the more now that with digital payment, there's the tip culture is also dropping, and it's almost ending, in fact, because people quickly pay on the UPI, they pay the bill and walk out. Earlier, if there was extra change, then you'd say keep it.
I would like to tell you here that you saw how the gig workers agitated, and the government had to think of some policy. Now everybody has to think on those lines before it goes out of control. So the restaurant owners.
But I really hope, Mr. Rao, are you going to place this proposal before the government, or was this just a suggestion?
No, this is what we have just made an attempt, or
so a formal attempt.
On trial basis, we discussed on this matter. You see, this is not going to be there in any fine dining restaurant. In fine dining restaurant, there will be a captain, there will be a service boy.
Okay, so you're saying smaller restaurants. So no, my clear question is: are you making a formal presentation to the government?
No question of present. We were just thinking of what to do.
Okay, that's it. So you're still mulling over it. All right. I wish you don't, and I wish people have better civic sense. Vinod?
Because customer is very
I'll just like to add.
Quickly.
Yes. I want to add quickly that
I will explain in a minute.
I have no time, sir. Vivek, I'll give you this 30 seconds.
Yes. No, I'd like to sum it up by saying that I have friends and friend's father who goes to MTR for the last 30 years.
Yeah.
And that is not a loyal customer. They go for their morning walks and their coffees to MTRs, and whether you want to see that the low-end customers also need to be thrown. They spend about an hour and a half, and they're doing it for the turn. So do you want to put a price on loyalty and, throw out these clients? I don't think so. It's a fair idea, for any restaurant. As Mr. Bijan Mishra said, maybe...
Vidyarthi Bhavan is packed. People love to go there for dosas, idlis, whatnot. But they are very quick. They move like a train.
Yes.
You eat it and that's it. Your plates are removed and people are already standing near your table to take the next seat. So it all depends on how the staff guides customers. I suppose that's a big solution that you could adopt. Thank you very much. That's all I have time for. Thank you. All right, a quick look at all our top stories. Let's start with what happened in the parliament today. Well, we're looking at Rahul Gandhi goofing around in the parliament. I'm going to start with this visual here, showing Rahul Gandhi almost nudging and trying to grab Prahlad Joshi's hand, asking him to join him in a press bite. Well, there you have it. This is Rahul Gandhi being goofy in the parliament today. That's really grabbed all social media platforms with these videos. Hilarious comments coming in on that. But while that said, you see Rahul Gandhi all smiles here. But the BJP is now all set to move a privilege motion against Rahul Gandhi after his remarks on the Lok Sabha triggered a major political showdown. Union Parliamentary Affairs Minister Kiren Rijiju has said Rahul Gandhi has made some serious allegations about prior notice or evidence violating parliamentary rules. He's accused Rahul Gandhi of misleading the House with false claims against the government, the Prime Minister, Union Minister Hardeep Singh Puri. In fact, the controversy began after Rahul Gandhi attacked the Prime Minister Narendra Modi, accusing him of compromising India's interests in the US trade deal that we've had. Gandhi has also raised questions over alleged links involving businessman Anil Ambani and Hardeep Singh Puri, Union Minister, with Jeffrey Epstein. Well, here Rahul Gandhi raised it in the parliament as well. Hardeep Singh Puri reacted strongly, denying the allegations. He said his only connection was a 2014 professional email to LinkedIn founder Reid Hoffman, copied to Jeffrey Epstein, sent to promote Digital India and Make in India when he was a private citizen. Calling the charges as a mere smear campaign and buffoonery, Hardeep Singh Puri has said his interactions were purely professional and that he was introduced to Hoffman through diplomat Tajay Rod Larson. Now, he's also stressed that although his name appeared in US court released emails, no US authority has accused him of any wrongdoing. Now, Rahul Gandhi, however, maintains that he is ready to back and substantiate his claims, setting the stage now for a sharp political confrontation. While all of this, you have Anil Ambani's name that's cropped up in the Jeffrey Epstein files and the emails there, where snapshots of clear conversation has come to fore. Union Home Ministry has now issued a new directive making it mandatory to play or sing 6 stanzas of Vande Mataram before the national anthem at certain official events. Until now, there were no formal rules governing how Vande Mataram should be performed, but under the new 10-page order issued on January 28th, the 3-minute 10-second version of the national song Vande Mataram will now be compulsory part of several state ceremonies. This is a rule. First Vande Mataram, then the national anthem. Now, this includes flag hoisting events, the arrival of the president, before and after presidential speeches, governors' official programs, and other government notified occasions as well. The order also clearly states that if both Vande Mataram and Jana Gana Mana are played together, Vande Mataram must come first. People will be required to stand at attention while the national song is played, just like with the national anthem. However, there is one exception. During news reels or documentaries, people do not have to stand as it could interrupt the program. The government has also laid down band and ceremony rules, including a 7-pace drum roll to signal the start of the song and maintain proper decorum. This move now is part of efforts to promote Vande Mataram, especially after discussions in the parliament happened during the song's 150th anniversary celebrations. For context, Vande Mataram was written by Bankim Chandra Chatterjee in the 1870s, became a powerful anthem of India's freedom movement. In 1950, the first 2 stanzas were officially adopted as India's national song, and now the government has formally defined how it should be performed at official events with all the 6 stanzas that need to be sung. A dramatic twist in the Kanpur-Lembongeri hit-and-run case. The mystery over who was driving that vehicle there has taken a new turn. A man now identified as Mohan, described as a hired driver, has now surrendered before a local court. He claims that he was behind the wheels, not the tobacco baron K.K. Mishra's son Shivam Mishra. According to this man who surrendered, Shivam was sitting beside him and had suffered a seizure at that time of the crash. But this claim comes after days of outrage, conflicting versions and serious questions about how the case has been handled so far. The crash itself was devastating. A Lamborghini worth 10 crores slammed into an auto rickshaw, motorcycle, pedestrians in Kanpur, injuring 6 people. One biker was thrown several feet into the air. Eyewitnesses and videos showed Shivam being pulled out from the driver's side by bouncers, quite literally, who then clashed with the locals as well. He was seen on the driver's seat. The driver reportedly locked himself inside the car initially. Yet, despite all the videos and eyewitness accounts, the FIR was only filed first against unknown persons. Shivam Mishra was named only after intense public and media pressure nearly a day later. This came and then came another shift. Shivam's father claimed that his son was not even driving. He was not driving at all, insisting the hired driver Mohan was behind the wheels, while Shivam was unwell and later taken for treatment first locally and then to Delhi. Now with Mohan surrendering and repeating the same claim, investigators say that they are examining the new version, but the focus is no longer just on who was driving it. It's also about how this investigation is being handled. Imagine if this is a lie, what a big lie, with the police as well almost ignoring and turning a blind eye to what the public has seen. The Lamborghini was not towed but driven to the police station, potentially compromising evidence as well. There was no bystander, there was no breathalyzer. In fact, we hear there was no breathalyzer test itself, no immediate medical testing for Shivam that was done, no confirmed forensic driver analysis, and no clear mechanical inspection, despite the family citing possible technical issues. So, no arrests have been made so far, no custodial interrogation, and only one local police inspector has been suspended for alleged negligence. Well, we're going to see what happens next here. Thanks very much for tuning in.
Ever wondered what makes the night come alive? Where flavors, lights, and laughter dance in harmony. When the sun sets, stories rise. Of kitchens, cocktails, and charisma. What makes your city's night so happening? Let's find out.
Good service, good food, and a good location. You need to explore, you need to experiment.
But they will never forget how they felt when they came to your restaurant.
Being a chef, it's my priority to deliver taste in a plate with good presentation, unique innovation.
My definition of mixology would be to get people drunk in a safe and happy way.
Don't drink on the job, that's for sure.
Mixology, you can play around with anything. You can create the stories, you can create the recipes.
Let's cheers on that note with our friendship.
Indulge in the finer things in life with Radico presents Lounge Nights. Discover the creme de la creme of India's culinary and nightlife scene. From trendy bars to exquisite restaurants, we've got you covered.
This isn't a trail of peace. This is pressure overload. A hill built for 1,000, forced to carry lakhs.
Instead of lightening the footprint, you have allowed people to actually get into every nook and corner of the Himalayas.
Careless travel, choking hills. If we don't change now, there won't be much left to enjoy.
We need to follow the Bhutan model, regulate people who can access hills.
News9 presents Heal the Hills, continuous coverage.
This is India's #1 news network, and you're watching News9, English news as it should be.
Hardeep Singh Puri hits back at Rahul Gandhi's charges over his mention in the Epstein files, denies any wrongdoing, claims he met Epstein 3 to 4 times as part of a delegation of the International Peace